Hello, this is Alexander Cross, criminal defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. So, we received an interesting inquiry here on our YouTube channel. This has to do with somebody who was accused of raping a minor. Let's see here. When I was young, I had a girlfriend, and we separated when we were 17 years old. Okay, so they're both minors. We had had sex since we were both 15 years old. After 10 years of separating, she accuses me of having raped her. Well, the first question I have is, well, at what age does she claim that you had raped her? Because if she claims that you raped her when you were both 17, well, this more than likely will end up going to juvenile court rather than adult criminal court. Now, rape still is a felony, regardless of whether or not you're a juvenile. It still is a felony that carries up to 8 years state prison, plus having to register as a sex offender for life under Penal Code Section 290. By the way, the code for rape is Penal Code Section 261 here in the state of California. Now, the question I have is, why did it take her so long to accuse you? Why did she wait 10 years after you guys broke up to accuse you? Also, a private investigator is going to have to be involved here because it's going to be necessary to see whether or not she may have spoken to a psychologist. Did she let a psychologist know in the last 10 years that she had been raped? Was the rape the basis for the breakup? Are there any text messages between her and some friends where she says that she had gotten raped by her old boyfriend many years ago? Because if none of that exists, it's going to be really, really damaging to at least to the prosecution, because it's really strange that she would wait so long. It would take away a lot of the credibility of the victim to wait so long to accuse him, because we're not talking about like a little kid who allegedly got raped. We're talking about somebody who may have been 17 when she got raped. So surely she would have spoken up very, very quickly. I don't see why she would have waited 10 years for this. Now, when it comes to the 261.5 charge, which is just having illegal sex, because both of them were still having illegal sex, the statute of limitations would have run out by now, and there'd be no basis to charge for the illegal sexual activity, even though it was consensual. But when it comes to rape, there's no real statute of limitations behind that. So it's not a statute of limitations issue. However, it definitely is a huge credibility issue, because I think there would be some difficulty believing the victim in this case unless there are some text messages or any kind of evidence indicating that for the last 10 years she had been traumatized over the rape, and now she's finally coming forward and going to the law. Now, if something like that happens, then yes, there would definitely be some problems, because then the victim would clearly have some level of credibility. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. But if you've been accused of a crime here in the San Francisco Bay Area and need representation, call us now for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who had domestic violence and attempted murder. Criminal lawyer, criminal lawyers. DUI lawyer, DUI lawyers. Criminal attorney, criminal attorneys. DUI attorney, DUI attorneys.